Committee. My name is Kevin Dimena. I'm here on behalf through Dimena and Associates of CAI. This is the organization that represents homeowners associations throughout Arizona. We don't represent management companies. We don't represent the landscapers. We are the associations and their boards, duly elected, and what have you. Throughout the course, what has happened over the years is individuals unhappy with various aspects of their HOA having failed to prevail with their HOA. They've tried to run for the board and been a minority. Or they have tried to propose changes to the CCNRs at the local level, all of which is appropriate, and they failed or haven't succeeded adequately. No one at this legislature was a party to that contract. Now, you can certainly pass a law and supersede what it says. Generally, in the practice of law, that's known as abrogation of contract. But we recommend against that. It's done frequently here. The other is a property rights issue. CCNR creates a degree of uniformity. It's a homogeneous environment. And what you end up with is a certain amount of value people seem to derive from this is when they look at it. Navajo white. If someone, a renegade member of my HOA, paints their garage door next to me fuchsia, my property has been devalued. If they put a ham radio tower on their roof, my property has been devalued. That's the reason that was one of the stipulations for moving into this complex. You're asked to sign this contract. Now, this legislation, which the staff has done a great job in outlining in fine detail the provisions, lower thresholds, and in some cases, my HOA, built in phases, is 35 years old. When it passed from the developer's control to that of the HOA board, these CCNRs were drafted 35 years ago. The Internet. Al Gore had not invented the Internet yet. Imagine the updates that have needed to occur, and some have occurred. They've been necessary. It requires 90% approval in this complex to get such a change made. Now, board meeting, member of the board, personal responsibility. I want to make sure that, and I think if you're a member of the board, they may blow the yard in front of your house a little extra. My point is simply this, that if you want to do something, the government that governs best is that closest to the people. And HOA boards are, in effect, little tiny mini governments. We've made it easier to recall and throw out bad board members. This legislation will lower the thresholds by going in, as this legislature regularly does, superseding contracts across the state, from Mojave County
Page 2 of our communication states that the validity of an amendment to the declaration shall not be challenged if the amendment was adopted in accordance with this act or in accordance with the association's declaration. Now, I've been around HOAs for about 25 years, both as a board member and as a property manager trying to work with them, and as an association manager. And I have witnessed several times where there's been a power play by a few members. They get into the board and they start passing rules that, quite frankly, are illegal. They're unlawful. And this here says that you can't challenge them if they've gone through the proper procedures. Is that what I'm reading or not?
No, I think, and great, Madam Chairman, what you focused on is, it's kind of a moot point, because proposing them and accepting them was to start down a path that wasn't legal to begin with. A challenge isn't necessary. They are moot by their very definition. They don't exist. So the idea here is to facilitate, probably need a lawyer, the elimination of those provisions without, in fact, talk about a challenge, but what you really get is something along the lines of a declaratory judgment, depending on small claims, however high you go. But in reality, if it's illegal, the HOA board can't, by virtue of its existence, make it legal just because they've passed it.
Well, let me share with you the direction I'm coming from, because I had a city manager who told me you can do anything you want when you have the majority votes, 4 votes, until a judge tells you otherwise. And that's what has been often the mantra of those who want to capture the board and run it as their fiefdom or their kingdom. And I guess this is telling me that, at least that how I read it, is that if it's done through the proper procedures and you get the votes, you can't challenge it. And so if that went before a judge, they would point that out very quickly. This simply says you can't challenge this because you agreed not to if it went through the due process in the HOA.
Madam Chairman, Representative, we have debated this sentence to a fairly well amongst our group. I would be very open to rewording it. We haven't really found a simple way to do that, but the basis of it is that HOA boards should be empowered to act. They should not be subject to arbitrary challenges, but, and particularly if they've done something against the law, it shouldn't be allowed to stand. It should be simple and easy to vacate this. And I'm trying to use terms that aren't associated with court. But you're right. Our next program is easier recall of bad board members. And that's a very subjective thing, just as any form of politics. So those that push in the direction you're describing ought not to be on the board, or ought to at least perhaps stand for election again. If this provision is offensive, I recognize its ambiguity. And at a minimum, I would suggest to Mr. Montenegro that it be reworked. If it can't be satisfactorily reworked, then it may just simply need to be removed from the bill.
Because basically what it does, as I read it, is it abrogates my legal rights to challenge anything that's been through the process, through the board.
Good. Madam Chairman, just to clarify, and the lawyers seem very clear on this, that it never existed to begin with. Challenge is a moot point, because just because an HOA board takes an action and the law says you can't challenge it, if it was illegal in the first place, it's sort of like two negatives, like they equal a positive. And in this case, two negatives would equal a negative. But I go back to my earlier comment that I would recommend to Mr. Montenegro, if the language can't be satisfactorily massaged, it should come out.